Welcome everyone to the IPP web conference, Washington's My Health, My Data Act, Ensuring Robust Compliance in 2024, sponsored today by Transcend. My name is Selena, a programming and speaker coordinator here at the IPP, and I'll be your host for today's program. We'll be getting started with the presentation in just a moment. Before we do, a few quick details. Participating in today's web conference will automatically provide IPP certified privacy professionals who are the named registrants with 1 CPE credit. A recording of this program and a copy of the slides will be available in your My IPP account under your My Purchases and My Recordings tab within 48 hours of the webinar's end. Feel free to post any questions that you have for today's panelists in the Q&A area at the bottom of your screen. We are greatly looking forward to the conversation today. I will now hand it over to our moderator, Cameron, to begin the program.
Thank you so much, Selena, and good morning, everyone. Good afternoon. And good evening if it is nighttime where you are. We appreciate everyone taking the time to attend this. We're really excited. Got some really awesome panelists here with me, very smart people, if I may throw that in there. But I'm going to go ahead and let them introduce themselves. We have Mike, Brandon, and Kay. So we'll go ahead and let it kick off with Kay. Go ahead and introduce yourself, Kay, and give us your favorite new movie or TV show that you've been watching recently.
That I've been watching recently, and the caveat to that is new. So hi, y'all. I'm Kay Royal. I am the Global Chief Privacy Officer and Deputy General Counsel for Crawford Company. We're global claims management, so I absolutely love it. I'm also co-host of the wildly popular Serious Privacy podcast, and my favorite new show that I've been watching or binging, oh my, you had to throw new in there. I'm surrounded by toddlers. I'm going to have to say Trolls.
Oh.
Now, the one I've been binging is West Wing, but that's not new. So I would say the new Trolls movie then.
Very nice. Mike?
Hey, everybody. I'm Mike Hintze. I am a partner with Hintze Law, a boutique privacy and data security law firm. I also teach privacy at the University of Washington Law School. And before all of that, I was Chief Privacy Counsel at Microsoft. The only new show I've watched recently, I watched the first couple episodes of this Netflix show, Resident Alien, which is kind of dorky and cute and light, but kind of fun. My partner Susan and I also recently binged Outlander.
Ooh,
Nice.
Nice. Awesome. Yeah, those are good ones. My name is Brandon Wiebe. I am General Counsel and Head of Privacy here at Transcend. Been with the company for a couple years. Before that, was at data and AI and comms companies, Segment and Twilio. I'm doing product and privacy counseling there. Most recently, I think a couple shows. The Tourist was really good. About a guy who sort of wakes up with amnesia in Australia and is being hunted and pursued, sort of espionage, nice. Amnesia type of thing. And Slow Horses was very good. Espionage show based in the UK. Yeah, those are ones I would recommend to check out.
Slow Horses. I'm writing that one down.
Love it. Well, thank you all for being here. Let's go ahead and dive in. So again, this is for the Washington's My Health, My Data Act. So let's go ahead with the first slide. So to dive into everything to make this make sense for everyone who's viewing, I'll go ahead and start the first question off with for Brandon. Brandon, what are the primary goals and objectives for the Washington My Health, My Data Act?
Yeah, it's a great place to start, and I think it's helpful to have a little bit of context on where this law came from, how it kind of came to be. So there were a whole sort of confluence of, I think, pre-existing trends that occurred kind of around the same time, and sort of in no particular order, just a rapid increase of digital platforms and health apps collecting and storing health information, some perceived gaps in the ability of federal law like HIPAA to regulate and cover those sorts of use cases of health or health adjacent data, since HIPAA really only applies to personal health information collected and processed by entities like healthcare providers and pharmacies and their service providers, their business associates. And then some increased concern over things like discrimination based off of health information, particularly around sensitive health data related to reproductive health services, for example. And so all these sort of conditions were occurring and growing and trending. And then what really galvanized the movement and gave birth to this particular law was when the Supreme Court issued the Dobbs decision overturning Roe v. Wade. And this created an increased concern that health data, and specifically reproductive health data that fell outside the protections of HIPAA, could be used to do things like deny healthcare access to consumers. And post Dobbs, there were a number of conservative states that had trigger laws that put in place sort of abortion bans. And progressive states like Washington State took a different approach, and their approach was focused on shoring up privacy protections, so filling in some of these perceived gaps that existed in HIPAA. And so as a result, the legislature passed this law fairly quickly and focused on, I would say, sort of four major things. So strengthening consumer rights around their health data. So empowering consumers with more control. This includes a lot of rights that will sound familiar to those who have studied the more comprehensive privacy laws that are out there. So right to access incorrect and delete health information, as well as some sort of more unique rights to opt out of certain data processing activities that we'll double click into a little bit more. It also focused on enhancing transparency and accountability on how businesses are collecting and handling health data, and requires sort of more distinct and separate disclosures around how that data is being used. We can talk about whether it is achieving the goal of transparency or muddying the waters there. I think it's worth a debate. And then expanding the definition of what is covered and what entities are subject to the law. So a big part of the thrust of this law is quite how broad it is. So the definition of consumer health data that's covered here is much broader than what we have typically seen for PHI, right? And then it also has a much broader scope in terms of the entities that it applies to. We can talk about what that means. And then the fourth pillar here is probably around security. So implementing strict data protection standards. It has sort of a robust security measures requirement as well. So those are sort of the major thrusts of the law and kind of where it came from.
Thanks, Brandon. Okay, how does this act differ from existing privacy regulations in depth, like let's say HIPAA, for example?
Well, they do have quite a few exceptions in place for data that is subject to other federal privacy laws, HIPAA, FERPA, Fair Credit Reporting Act, things like that. But it's interesting that in some of these that it brings in more data necessarily than what data is regulated under those acts in particular. So you may find yourself subject to additional controls, or you may be subject to widely varied controls in Washington versus outside Washington. Now, it differs quite a bit from other state privacy laws that were in effect. So I think there's 14 state privacy laws now, although I think I just saw that Kentucky is waiting on the governor's signature, so that might make number 15, but 14 state privacy laws, omnibus laws in place now. These do differ. So we do know we have a lack of consistency across the state laws, but there are quite a few things that are similar. So when you come down to the basics, the Washington My Health, My Data Act has the basic. It has consumer rights. It has protections. It has who is subject to the law. It has the exceptions, the expectations in there, the do not sell, things like this. I wouldn't say the problem. The key point is Washington just goes that next little click that you might not be expecting out of a state omnibus privacy law, and this one wasn't expected to be an omnibus privacy law, but due to certain definitions and the way that it's enacted, it could conceivably be considered an omnibus privacy law in many respects.
Yeah. And Mike, can you elaborate from your perspective on the scope of this act and maybe some of its implications on businesses operating in Washington?
Yeah, for sure. The scope, as Brandon and Kate suggested, is very, very broad, and it's very, very broad in a couple of ways. It's broad in scopes of the entities that are covered. It can apply to any company that's doing business in Washington or is providing a product or service to people in Washington. So that could be any website or app or service that's online available to people in Washington. It applies to consumers, and the definition of consumer is not just Washington residents or people who are getting services in Washington, but it's anybody whose data is processed in Washington. So there could be individuals who have really no connection to Washington, and their data is uploaded and stored in a cloud service provider located in Washington state. And there are some very large cloud service providers located in Washington state. And then the definition of consumer health data is extraordinarily broad and in many ways quite vague, in ways that could potentially sweep in any data that even has any relationship to health or wellness or nutrition or fitness or any categories alike. And obviously we won't have time to go through and parse every aspect of the definition, but I just want to highlight a couple of pieces of that definition because I think they're really important to illustrate how potentially broad this is. So the definition of consumer health data has a general part that talks about past, present, or future physical or mental health status. But then there's a laundry list of specific things that are by definition considered consumer health data. One of which is data that identifies a consumer seeking healthcare services. And healthcare services, in turn, is defined as any service provided to a person to assess, measure, or learn about a person's health. So any information service, any search service, you can imagine, a grocery store providing nutrition tips, heart-healthy recipes. It would be a service to help people learn about or improve their health. Gyms, yoga studios, meditation apps. Potentially all of these are swept in by that and other aspects of this definition that are extraordinarily broad and in many cases quite vague, leading to some really difficult challenges companies are going to have about determining whether or not this particular data that they're processing is in or out. And then just on the substantive obligations, I'll just note some of those challenges. Kate said it's a little step beyond. I would say in some cases it's a very big step beyond in terms of some of the obligations that this statute puts on. So, for example, it has rules around data sales. In California, data sales are an opt-out, right? Here, it's not only opt-in, there is a higher standard beyond opt-in that they call authorization, which is essentially a lengthy written signed document that expires after 1 year, is revocable at any time, that has to specify the particular information to be sold, the name and contact information of the seller and every buyer. It's such an onerous authorization process for anything that would be deemed a sale that in some ways it's going to be very, very challenging, especially at scale, to deal with. Some of the consumer rights, yes, there are access rights and deletion rights, but we don't see the exceptions in the deletion rights that we see in virtually every other privacy law on the planet, including exceptions for when there's a retention of the data is required by law. So there's all these, and then the access rights have additional obligations to provide information that we don't see in other privacy laws. So yes, the basics are there, but there are aspects of this law that will require companies to go back and say, okay, I've already got this in place. Where are the gaps? Where are the deltas? What do I need to do beyond that to comply with this new set of requirements?
That's great. Let's go ahead and move on to the next. So exploring business implications, let's dig deeper into that. This first question is going to go to Kay. What are some of the key challenges that businesses may face in complying with this new act?
Well, most of them are exactly what Mike has already mentioned. I mean, you really do need to understand where Washington goes beyond what we're expecting right now. So the first challenge is, are you subject to it? The second challenge is, if you're not subject to it, but your customers are, what are your responsibilities when it comes to that data? And that might need to be an open conversation with your clients if it is, because if it is triggered on where the data is processed, if the data is processed in Washington, then you need to know what your data flows are, and are you processing data in Washington, even if it's not Washington resident data. That's not the trigger for the law. So you need to look at those very, very carefully and understand your data mapping. And a lot of companies, I mean, they're so sick of hearing about map your data, map your data, map your data. We get it. It's not a very comfortable exercise to go through. Nobody enters that going, yay, let's go map some more data. But it really is. You do have to understand where your data is and where it's going. So after you determine, is it applicable to your business? But in that, you need to figure out those key concepts. Are you a regulated entity? Do you collect data from those consumers? Is it consumer health data? Those are very, very broad. So don't take a very narrow concept when it comes to that. You need to look at the data privacy policy. It has to be separate and distinct from any other policies that you have. So you may have a separate California notice right now, because California allows you to get out of certain things if you have a separate California notice. So now do you need a separate Washington notice? You need to look at that. And I know some people or some companies are taking the perspective of combining it, saying it is U.S. state notices and includes California in there and other states. You can't do that. It has to be separate and distinct. Make sure you're abiding by those consent and authorization when you're looking at it. If you do any type of geofencing, make sure you identify where that's happening as well. Those authorizations that Mike mentioned, let me go back to that one real quick. It is an authorization. It is separate. So it's separate from consent of being able to collect their data and use it. This is an authorization to be able to sell or use it in advertising. So you need to do that. And again, as I said at first, if you're not subject to it, are your clients subject to it? Well, the clients need to turn around and look at which of their vendors they need to pass these responsibilities down to and coordinate with them of how they're doing. So there are a lot of things you need to take into account that are challenging, that you need to make sure that you understand and you document and you take a very thorough look at. A lot of times we tend to take a very narrow look at things. You cannot take a narrow look at Washington. They may not have intended to write it the way they did, but it's written. And this is what we're left with, and you need to take a very broad interpretation of what you have, because the penalties are pretty wild.
There's a womp womp there.
Yeah. We don't like to use the stick or the carrot. Washington doesn't really have a carrot, let's be honest. But you don't like to use the stick. But unfortunately, that is what a lot of executives understand, is what are the penalties? What are the risks? And you might say, well, us getting caught by Washington, my health, my data is not a big risk. Really? Might want to reconsider that.
Yeah, challenge accepted.
Yeah, right.
Thank you, Kay. Brandon, digging more into it on the business side of things, the size of things, not side. How does this act affect small and medium-sized businesses compared to those larger companies?
Yeah, I just want to add one thing to what we discussed so far, just to make sure it doesn't get lost. So on sale of data, there's this valid authorization requirement, which is sort of this onerous written sign type of requirement that effectively may be a ban on sale of consumer health data for most organizations. The other thing to just call out is that the law authorizes entities to use consumer health data only as necessary to provide services, unless you have received consent. And that consent is very much GDPR style, very specific, informed type of consent. And you need a separate consent if you are doing something with the data beyond what is strictly necessary. and if you were doing something with the data that goes beyond what you've disclosed in your notice. And those are separate types of consent. So this is a very unique sort of opt-in regime. I flag that because your question, Cameron, was on how does this affect small and medium businesses versus large businesses? So the short answer is that while there is a definition of small businesses that sets sort of a lower threshold around data records in the law, substantively, all of the same provisions apply to small businesses. The only difference is that the law becomes effective for them 3 months later. That's really the only change. What the actual impact of that will be varies. So a large organization that has a lot of data, particularly potentially PHI data that was regulated by HIPAA, intermingled with data that now might be regulated by this Washington law, can be very complicated and very onerous. And for large organizations like that have sort of data sprawl everywhere, it is going to take some time to work through and do the very complex data mapping, data flow exercises to assess how you're going to sort of tease that out and make some decisions around how you're going to plan for compliance here. For the small businesses, I also think data that is used for secondary advertising purposes can be the lifeblood of those businesses to give them an advantage and generate revenue and move forward. If they are using consumer health data as defined by the law for those purposes to help drive revenue, drive retargeting, they're going to have to revisit those practices, and it can have a potentially significant impact if they have to go and get actual consent before they're able to do these types of activities. So I think it applies equally to both, but the impacts vary based off of the type of business that you have.
Yeah, that's great. Thank you for going into that, Brandon. Mike, when it comes to your experience over the years, can you provide maybe some examples or just hypotheticals of how businesses need to adapt to this new act?
Yeah, I mean, it's every business is going to have to, think carefully about how they are going to approach this. And, for folks who are listening to this and are maybe hearing some of this for the first time, when we talk about the very, very broad scope, and in some ways very vague and ambiguous scope, and the very onerous substantive obligations, and I don't think we've said the word private right of action yet, but combine that with a private right of action, some folks are probably hyperventilating at this point. But I think, companies need to take a deep breath, figure out how this is likely going to apply to them. And in some ways, this is one of these things like, perfect compliance may not be literally achievable, right? Risk-free compliance. Well, let me say risk-free compliance because there are so many unknowns here. But I think there are some reasonable risk-based approaches that companies should be taking and thinking about, right? When you think about the data that you are collecting, there's a lot of data that could be within scope, but there's some data that's going to be higher risk that is clearly in scope, right? If you're dealing with, fertility and reproductive data, that is going to be high risk. That is squarely what the Attorney General has been talking about. Those highly sensitive data categories are probably going to be riskier. And so thinking about how to perhaps prioritize compliance efforts around some of those things. And I know we'll talk about enforcement later, but I do want to emphasize that although there is a private right of action, there is not statutory damages like there is with BIPA, for example, in Illinois, the biometric privacy law, where we've seen a ton of litigation and a lot of gotcha cases where, somebody made us, didn't put the right, words in the notice or whatever. Here, this is enforced by private plaintiffs as a violation of the Washington Consumer Protection Act. And to recover under the Washington Consumer Protection Act, you do need to show injury. And so I think when companies are looking at risk-based approaches, there are scenarios where you can imagine, and the plaintiff's counsel will obviously be very creative and aggressive here in asserting injury, right? But you can imagine cases where that's going to be a heck of a lot easier than others. There may be some scenarios where it may be very, very difficult to make any kind of credible claim of injury. And so I think companies need to think about that, and they need to prioritize their compliance efforts, because doing everything according to the letter of the law, taking the broadest possible interpretation of this law, will be either very, very expensive or darn near impossible. So, taking those kind of risk-based approaches, thinking about how this is going to impact your business, thinking about where the gray areas are, where the clear areas are, what the deltas between what you've already done and put in place, and then taking some smart risk-based approaches to that, I think is the right path forward.
Yeah, agreed. And this is just coming off the cuff in my mind, but between all three of you, PHI data and health information is probably the trickiest in all of sensitive data. Would you agree with that? Just because of the personal, like real personal information that could be about a patient or whatever. It seems to be the trickiest in terms of these laws, and it's just very. Go ahead.
I would say, picking up on something you just said, you said trickiest when it comes to patient information. I think that's clear when it's patient information.
Yeah.
What's not clear is when it's health information that is not clearly patient information. Mike has a wonderful blog series on the Hintze Law that talks about all the inferences that you can pick up out of this. What's not patient data but related to bodily functions or health. I mean, I think the law was built on tracking menstruation. It was in response to all the Roe v. Wade fallout, and everything in some states requiring reporting of certain activities. Some activities, a woman's menstruation, doesn't occur 24 hours a day. It's supposed to be intermittent, on a regular cycle, but other people may have bodily functions that occur every day. Every day you urinate, or you should. If you're not, please go to the hospital. But the fact that you're not urinating is also health data, but that's not patient data. I'm sorry. I was a registered nurse. Trust me. A lot of things come to my mind here that people can talk about. But, the fact that maybe your feet stink, is that health related data? Are they stinking for a particular reason? So the fact that you need to buy Dr. Scholl's, stinky insert things, is that health related data? That's what's not clear here. And I believe Michael and Brandon will both agree with me that the FAQs put out by the Attorney General didn't really clarify a whole lot of that. He spoke to some very specific elements, but not to this inferred health data. So where you say that the health data is the trickiest, you're absolutely right. But maybe when it comes to patients, it's a little more clear than when it comes to the general population.
I'll add one thing to that. I think one area that's going to be particularly risky and tricky here is when we're talking about location information,
right,
and the intersection of location information with health-related information, particularly information that could reveal somebody seeking healthcare services. Because not only is location information that reveals somebody seeking healthcare services part of the definition of consumer health data, if that location information is being used in a way that would meet the definition of geofencing under this law, there are specific prohibitions on certain uses of geofences. This is not something that requires consent. Consent does not cure this. These are outright prohibitions. There are things that are unlawful to do with location information that could constitute a geofence under this law. You just can't do it.
Yeah.
Great points. Let's go ahead and move on to our next slide. So talking about that data mapping, every executive's favorite thing. Brandon, why is comprehensive data mapping crucial for this act for compliance?
I was sad to hear Kay say that data mapping is never a fun topic. I live and breathe for data mapping. No, in this case, for this law, I think there are sort of a number of different provisions that, in order to comply, in order to even get to sort of a good faith level of compliance, you're going to need to go through the data mapping process. Anytime we talk about a new privacy law that comes out, we talk about the importance of knowing what data you have, where it's being processed and stored, where you are sharing that data to whom, which affiliates, and that's always true, always the case. I think there are some unique aspects of this law that add to the requirement here. So one is just sort of the threshold question about whether the law applies, and so as Mike and Kay have already talked about. The breadth of applicability here is unique for the law. Even if the entity is located outside of the state of Washington, the consumer is located outside of the state of Washington, but the data is being processed in a data center in Washington, you need to know that so that you can determine whether this law applies to you or not, right? So knowing what your cloud service providers are, where that data flows, that will be important. That is a crucial aspect of any data map. And then I'll flag just a couple of other sort of unique requirements. So in the privacy notice requirement, there's a lot of sort of the standard stuff that you expect to see in a general privacy notice as well. So categories of information that are collected and processed. But there's also sort of a new, more unique requirement, which is a list of the categories of third parties and specific affiliates with whom the entity or the small business shares consumer health data. So that list of specific affiliates, you're really only going to know that and be able to disclose that if you've gone through and checked, well, where am I sending this data? What affiliates am I sending it to? Do I feel confident that is accurate and up to date? And then similarly, when a consumer exercises an access request, this is also one of the things that you have to disclose to them is a list of specific affiliates. So knowing that information, and then once you've done your initial data map, having a way of managing if you add a new affiliate and the data processing has expanded in some way, knowing that you have to go and get new consent because this goes beyond what you've disclosed in your privacy notice. And you're also going to have to update that notice going forward for new users and new data collection is all going to be powered by an accurate, as close to real-time data mapping process as you can get.
Thanks, Brandon. Mike, what are what are some of the common obstacles organizations usually encounter or may encounter when mapping their own data for compliance here?
There's a lot of obstacles people have when mapping the data, and some of which are not unique to this law. But I think the things that are unique to this law are, some of the things that Brandon mentioned. You may have mapped data and know what third parties it's shared with, for example, but you may not have gone that extra step and figured out, exactly what locations that data is in. Or maybe you did it at a country level. Maybe for European purposes, you wanted to know when the data came to the United States, but who cares whether that's in Florida or Washington? Now that may matter, right? And then, the other point Brandon made about the access rights. The access rights, you need to not only map the third parties and affiliates with which that data has been shared, you now need to build that into your data subject access process, right? So that data can be pulled. If somebody says, I want to know who you shared my consumer health data with, you need to provide a list of third party and affiliates. And here's the other interesting part of this law, and an email address or online contact information for every one of those third parties. I guarantee you nobody has that as part of their data subject rights processes today. So being able to do that kind of mapping, gather that kind of information, and feed that into processes that may not be fed into today are something that, is going to be required under this law.
Awesome. Thank you. That's some good insight there. Kay, being at Crawford Company in your seat, can you share some of your visions on best practices or strategies for effectively implementing data mapping?
I'll speak from it, but not necessarily from the perspective of what I'm doing now, which, by the way, I didn't provide the disclaimer up front. These are all my opinions and have absolutely nothing to do with Crawford. They're a publicly traded company. I am a wild card. So based on my own experience, and I was a consultant for many companies in building up through the GDPR and the CCPA, and also I've been heavily involved in data mapping. So the strategies are, you need two perspectives. You need the technical perspective, which please utilize help. Buy Transcend, buy whatever system can help you discover data, classify data, and map the data. You need that technical perspective, but you also need the business perspective. You cannot rely on one versus the other. So the technical perspective can tell you if you're collecting social security numbers, which one of the biggest hints I've ever learned is if there is any way on this green earth to avoid using a 9-digit number for anything other than social security number, please find a way to use something other than a 9-digit number. But so the tool can tell you if you have social security numbers. They can't tell you why you collected them, or why you've populated them into that system, or why you're sharing them to that vendor. And don't rely on just one answer versus the other. There was one company we were doing mapping, and I think it was a performance review mapping of, well, who needs access to the performance review tool? And it's the supervisor and the employee and probably HR. What data does it collect? Very minimal data, right? Your goals, your performance, emails, your title, things like that. When we actually went to the tool, which I think was ADP or something like that, there were actually something like 180 data elements being shared in a performance review, which the business people knew nothing about. So don't rely on one or the others is probably the biggest strategy point that I can say is use both. The challenges are going to be nobody wants to take the time to give you that detailed level information. So do your best to reduce the burden on your business colleagues to identify it. But you do want to go to the details. Earlier, they said maybe you only mapped it to the country. If it goes from the US to Canada to Spain to Australia, now you need to map it on the state level. But do you need to map it to the point of, oh, I hired this company and they have a consultant that's now in Washington and that person's processing the data because they're helping us do something in particular, doing fraud investigations or their legal advice or something, and their person lives in Washington even though the firm is in California. Do you need to go to that level? Is that data being processed? Because there's no limit on quantity here. One person and you're subject to the law. So you might need to go to that level of detail. Do you need to go to the level of detail? Well, my person's on vacation. Now I have an employee that's in Washington that's there for a week, and yes, they're doing work while they're there. Maybe. These are the challenges. These are probably the things that'll be sussed out as we start seeing enforcement come through. And people challenging the different enforcement. These are probably some of the issues we'll start seeing come through that we might get decided later on, but we don't know how judges are going to decide these actions. We don't know what side they're going to fall on or what kind of tone we're going to start taking. Mentioned earlier, the Attorney General put out FAQs that might be taken as guidance, but as y'all know, and an informal opinion, these are guidance, these are not a formal AG opinion, has absolutely no bearing on judicial decision making. So we don't know what your best strategies are going to be. So I would say do a darn good job on data mapping. That's my advice. Do a really, really good job.
Agreed. Thank you, Kay. Let's go ahead and move on to our next one for strategies for compliance. Mike, what are some of the essential components of robust consent mechanism under the Act, in your opinion?
Yeah, as we talked about before, there's two types of consent. One is consent. Well, there's that higher level authorization for anything that would constitute a sale of consumer health data. Let's put that aside for a moment. For anything that is beyond what's necessary to provide a consumer requested product or service, or beyond what is disclosed in the privacy notice, you need to get GDPR level consent, which is, informed, specific, voluntary, et cetera. All those adjectives that are used in the GDPR definition, those are copied over here. So GDPR opt-in consent for anything, essentially what's beyond necessary to provide the service. I think there is a really big question to be answered here, and we don't know how the courts will come out, but how do you interpret necessary? Right? Are we talking strictly necessary or reasonably necessary? Because there's a pretty big difference there. A lot of back-end business operations that are, effectively necessary to operate the business in support of providing the service could be determined as necessary. But if courts start interpreting that as strictly necessary, maybe not. So I think, figuring out where you're going to draw the line about what triggers consent, and then figuring out how many separate consents you need to pop, because there needs to be separate consent for uses that beyond what's necessary. And then if you're doing any sharing that's beyond what's necessary, that has to be a separate consent too. So, looking at what consent mechanisms you have in place, are most of the things that might trigger this cookie-based? Do you have a cookie banner today? Could you flip it to opt-in like you might be doing in Europe instead of, opt-out like you might be doing in the US elsewhere? How can you leverage existing consent mechanisms that are in place? And then again, are there gaps? Are there deltas where you might need to do something more, where you might need to configure it differently? But, the first step is, again, coming back to like data mapping, figuring out what the data you have, figuring out where your uses are, and then deciding what uses you are going to determine go beyond either what's necessary to provide the service. I should also note there is a security related exception. So data that's used for security related purposes doesn't necessarily need consent. So, just kind of figuring out those scopes, looking at what you have in place and figuring out what more you need to put in place for that.
Great. Thank you, Mike. Brandon, how can organizations ensure that their privacy policies are met at the stringent requirements here for this act?
Yeah, so the law includes a fairly detailed set of requirements. We talked about some of them around health privacy notices. The contents of the notice itself, as mentioned, are oftentimes very similar to what you would sort of see in a general privacy notice. So it's things like the categories of consumer health data collected, the purpose for which it's collected, the categories of sources from which consumer health data is collected, categories of consumer health data that is shared, and then sort of the unique one, which is the list of specific affiliates with whom the regulated entity or the small business is sharing that data. But what's particularly unique here is that it needs to be a separate and distinct notice. So it cannot be embedded in a broader comprehensive privacy notice. It cannot be sort of nested under that notice as a separate section. Oftentimes folks are doing that with sort of the California consumer privacy rights section of their notice. That is not acceptable. It's very clear under the law and under the AG's interpretation that this needs to be a totally sort of standalone page, standalone document. The other piece of this is that on every homepage, there needs to be a link to this notice. And homepage is not what you think it means. It is not the sort of index page or the main page of a website. It's any web page where personal information is collected. And that's not covered health information. That is personal information. So you think about the broad scope of personal information that includes, browser telemetry data, IP address, things like that. Basically every page should have a separate and distinct link. It is not a link that you can hide behind another link. It needs to be sort of a standalone piece here. So I think between sort of the unique contents, the fact that this is a standalone document, and the fact that you need to link this separately on basically every page of a site are going to be sort of the key pillars of making sure you comply with the notice requirement here.
Thanks, Brandon. Does it age me well that when you said homepage, I thought of the MySpace top 10 back in the day?
Absolutely.
No? Anyone else? Okay.
You would have been in my top 8 places, Cameron.
Yes. Love it. Okay. Do you have any personal just opinions? Not
Yeah,
from-
my daughter's had MySpace. There's my personal opinion.
No, on the specific like compliance, do you have tactics or strategies?
Absolutely.
Yeah.
So here's the thing. There's a lot of resources out there. I mentioned before, Mike's actual blog is one of my absolute favorite resources to go through. But there's a lot of resources out there that detail what you need to do. But frankly, for my strategy, I would read the law in conjunction with the helpful resources out there, because you really do need to look at each word of it. So strategy for compliance, if you're not using a framework to manage your privacy compliance program, then you're missing out on a lot of wonderful little cohesive areas that you can have. And I'm picturing this like a big grid in my head. You know, you have your compliance framework, you know, you have transparency and notice, take notes of what you need to do different for Washington. There's little notes you're going to make for each of the states and maybe little notes for some of the countries out there of where the differences are. So you have a baseline compliance, and then you have a list of what you need to do specifically for Washington. Now, does this mean that you're going to need to keep up with this list as you go? Everything you do, you're going to need to compare it. Yeah, you're going to need to go back to your checklist and make sure you're not doing something new that you need to change your privacy notice. And do you need to change your Washington privacy notice? And then just make sure you're paying attention to, once enforcement starts, what those decisions are. Now, is this going to be really, really quick? It goes into effect, you know, in March. Everyone else has 3 months. The small companies, have an additional 3 months to come into compliance. Does that mean we're going to immediately start seeing enforcement in April? I would ask Mike that. I think he's probably closer to that than I am. I don't know that we're going to see really, really quick enforcement. And you know, here in the US, if there's any type of enforcement, companies are going to fight it. They're going to fight it up until there's a settlement. If there's a possible settlement agreement, I think one of the interesting things is the Attorney General does not have rulemaking authority under this. Now, maybe there's going to be an amendment and they're going to get rulemaking authority, but that does mean it's essentially the law that you're following. So compliance, keep good notes, follow a framework, pay attention to decisions and settlements that are going to come out, and pay attention to either your clients or your vendors. Your clients are going to tell you what their compliance needs are. You need to communicate. Your vendors are going to tell you what they can and can't do. Is anything they do with your data going to make you subject to the Washington as well? And make sure that you update those vendor contracts. Third-party risk management is a real thing, and it's something you really have to stay on top of.
Great. Thank you, Kay. Speaking of enforcements, we'll move on to our last major slide here, and then we'll open the floor for some open questions at the end. So understanding enforcement measures. Mike, we'll go ahead and start off with you. Can you provide some insights into some of the enforcement mechanisms outlined?
Yeah, so as I mentioned before, it's enforceable as a violation of the Consumer Protection Act. Both the Attorney General can enforce it and private plaintiffs can enforce it. Under the Consumer Protection Act, private plaintiffs do have to show injury. And what's interesting about the showing of injury, that's show causation and injury. So the violation needs to have caused an injury. And the language under the statute is really interesting under the Consumer Protection Act in Washington State. It's injury to business or property, which would make you think you have a lot of comfort, like they would actually have to show monetary damages in a commercial or a property sense. I don't know how the judges are going to interpret that in light of the legislative findings behind this statute, because the types of injuries that were discussed through the legislative process and are presumably motivating this for all the reasons that Brandon outlined so well at the beginning. I think judges, elected judges in a very progressive state like Washington State are likely to start interpreting that a little bit more permissively. I still think companies can take some comfort in the fact that plaintiffs will have to show some kind of credible injury, but I think courts may be a little bit more permissive than they have been in what that injury needs to look like. I don't think it has to be monetary, but I do need to think, take an example. There's a lot of talk about using health data for advertising purposes. And we've talked about the broad scope of health data and how there may be some opportunities for risk-based prioritization here. So information about hay fever is clearly inside the definition. But if you see an ad about hay fever medicine and your coworkers see that over your shoulder and you claim that that somehow injured you, that's going to be a tough case to make. If you see an ad and you're at work and your coworkers see it and it's around, reproductive health or pregnancy or ED or cancer, you might be able to make a claim that injured you in a, way that could justify recovery. So I think that the fact that there is that hurdle for private plaintiffs to overcome, I think needs to go into the consideration about what is the risk and how are you going to prioritize your compliance efforts. The Attorney General, interestingly, does not need to show injury. But the Attorney General is going to be motivated by, certain policy objectives. And again, probably reproductive health is going to be much higher on the Attorney General's agenda than hay fever, or, general nutrition, exercise, or things like that. So the understanding the enforcement mechanisms and the hurdles that the two different enforcers, the hurdles and the motivations of the two different enforcers, I think are important here.
Right. Thank you, Mike. Brandon, what are some common compliance pitfalls that businesses should be aware of to avoid some of these enforcements?
Yeah, I think keeping in mind as we go through these exactly what Mike was just alluding to, that it's important to take a risk-based approach. And if you are the sort of entity that is processing information that is likely to read on very closely to the sort of injuries that the legislature was trying to identify and mitigate here. Related to things like collection and processing of reproductive health information, that sort of information, then you need to pay much more attention to this. If you are in that sort of category, I think there are some areas of very visible compliance that the Attorney General and that the plaintiff's bar can go to your website and identify very quickly. So how your consent mechanisms are set up and how they are suppressing data flows is something that is sort of very easily publicly auditable. And there's also some precedent beyond just the Washington law around collection and sharing of health data and enforcement in this area. The FTC in particular has had a big focus on this. We've seen this pop up in application of other sort of older non-privacy focused laws. And so this is because this is so easy to track and to identify and to audit without having to actually issue an enforcement action or a letter. This is going to be an area of I would say low-hanging fruit that folks need to focus on. The other piece of this is going to be on the privacy notice side, since that is a clearly visible requirement. Having the separate link, having the separate policy that discloses what you're tracking, and then making sure that what you have disclosed is matching what your website shows all of your ad trackers actually are. This is another area where it's very easy to go and audit what data flows are emerging from a browser, what calls the browser is making to different URLs, and see where that data is flowing and see whether that matches what the entity has actually disclosed in their privacy notice. So I think if you have sort of shored that up, you are going to be at a greater advantage of not being focused on by the plaintiff's bar, by the attorney general. And so those are sort of the key tips I would give here.
Awesome. Thank you, Brendan. Kay, to wrap things up on this one, how can organizations look at a proactive approach in mitigating compliance and ensuring, some ongoing adherence to this act and their requirements?
Well, basically, this is everything that we've been talking about. So understanding the law, understanding if you're subject to the law, understanding if your clients or your vendors have things that you need to pay attention to, your data flows. Do you have the consents in place? Do you have the authorizations ready to go? Do you have your separate privacy notice? So what can you do proactively? Well, we're in March. Pay attention to the law and to the enforcement dates. Make sure you have a program plan down. I would also say that privacy, unlike a lot of areas of law, documentation is key here. So if you notate out the law and you've looked at the advice, you understand what's being asked, or to the extent that we can all understand at this point, document what you have. If you've got your data flows and you've fulfilled them and you have all your processes out and they're complete and you've looked at it and you haven't identified any data that's being processed in Washington, then oops, when something is found later, you have the documentation to show that you went through the exercise of doing it. In health as well as in privacy law, if it's not documented, it didn't happen. You can tell a judge or an attorney general all day long that you did this. I had my privacy notice written and ready to post, and then we determined that we weren't subject to it. You can't prove any of it. So I would say make sure that you're building your case as if you were going to court. That's probably a good way to look at a lot of these things, not necessarily the stick, but just making sure that you've got the documentation and the controls behind you to show that you're on top of it. I believe that some of the judges are probably going to lean into the very broad provisions of the law, and other judges will not. So you're not going to know what side you're going to fall in versus the other, but build it as if you're going to fall into one of the judges that's really going to lean into the broad interpretation of the law. Probably go against what the attorney general may be saying they're looking for and build your case. Does it need to be rock solid? Probably not. This is a very changing piece of law. And I wouldn't say the piece of law is very changing when it comes to the interpretation. The law itself is it is what it is. It's within the black letter lines, but the interpretations could be changing, as we've all spoken to throughout the meeting. So I would keep a very open mind about what it is that you need to do and make sure that you document and get your ducks all lined up and all of that good stuff. I mean, there's a lot to do. There's a lot to do. And if you hadn't already started, you need to. That's probably the biggest tip out there. Even if you're a small business and you have a 3-month delay, it's only a 3-month delay. And I think that probably tees you up, Cameron, for one of the questions that we got about the enforcement and the delays.
Yeah, I think Mike's typing right now for it. But we can kind of, if anybody wants to chime in here, since we got open questions, we can answer that.
Yeah, so the question we had is, do we anticipate legal action to challenge portions of the My Health, My Data Act or to postpone enforcement? And I think, Brendan, I was just reading the question.
I'm going to throw it over to Mike. I'm curious what Mike thinks about this. I haven't heard of any challenges in this area. I don't personally anticipate any, but Mike, have you seen anything different?
I don't anticipate any, certainly not anything proactive. I think, because of the way this law has been positioned, it was a very challenging legislative environment.
Yeah.
Companies did not want to jump in and oppose this law, at least in their own name. Some worked through trade associations and the like. But because this was being positioned in response to Dobbs, supporting women's reproductive rights and other essential, other healthcare services that are under threat in parts of the country, no company wanted to jump into that and say, no, we're opposed to that.
Right. They didn't want to
and
be
I think-
seen in that
and I
light.
think that dynamic is playing out in terms of companies not wanting to, take proactive court challenges to this. Now, in the context of an enforcement action, will there be pushback? Certainly on certain pieces, particularly if the focus is outside of some of those sensitive areas where companies may make the calculation that challenging it rather than a quick settlement is the right choice. Maybe, but I don't see any proactive litigation that is going to challenge the law on its face or delay enforcement.
Agreed.
Yeah, I think that's right. It's also unique because there's no regulatory rulemaking authority here as well, and oftentimes you see challenges in that context where the regulator has potentially exceeded the scope of what's authorized under the law. I think you'll see this play out in litigation, and maybe bits try to be chipped off here or there at various motion practice stages, but I don't see any big sweeping challenge.
Great. Well,
Agreed.
Catherine, thanks for the question, Catherine. And thank you for everyone that has taken the time to attend this. Thank you, all three of you, for your expertise and opinions here. This is amazing. And I think everybody that's attended this will receive this this slide deck as well. So go ahead and please follow everyone here on LinkedIn. And thank you, everyone, for being here.
Thank you so much, Cameron.
Thank y'all.
Thanks, everyone.
Thank you so much, Brandon, Mike, Kay, and Cameron, for sharing these super valuable insights with all of us today. I also want to give a big thank you to Transcend for sponsoring today's webinar, so that is free to our audience. That wraps up the program here today. Thank you again for joining us, and we hope to see you in another IPP web conference soon.